Welcome to Bearpaw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bearpaw Media and Education is a department of Native Counseling Services of Alberta, and our primary goals are to make public legal education understandable, accessible, and affordable for Indigenous people. We at Bearpaw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities and is edited by lawyers. Of course, laws change with elections and societal values, so this information is designed to be general in nature and may not apply to your specific situation. It still may be necessary to consult a lawyer for legal advice to assist you. For more information, you can go to our website at bearpawlegalresources.ca or follow us on social media at Bearpaw Legal. I'd like to begin by acknowledging that the land in which we gather is Treaty 6 territory and a traditional meeting ground and home for many Indigenous peoples, including the Cree, Saulteaux, Blackfoot, Metis, and Nakota Sioux. Today's topic is going to be on the ABCs of the Child, Youth, and Family Enhancement Act. So I'm going to start by sharing part one of a three-part video. We at Bearpaw have created lots of resources on family court, so you'll want to make sure to check out our website. There are several videos as well as publications that are all related to family court. So this will be part one.
Hello, my name is Hope. I'm here to help guide you through the Alberta Child, Youth and Family Enhancement Act. NCSA court workers are located all across Alberta. Please check the inside of the DVD cover or the website www.ncsa.ca for locations and contact numbers. If you're involved with children and youth services, you should seek legal counsel immediately to be sure you understand your legal rights and responsibilities as a parent. An NCSA court worker can put you in touch with legal aid. We have created 3 scenarios that may be relevant to you. I'll explain what is happening and walk you through the process as it would happen in real life. Let's check out our first video.
Hello, Caseworker Brown speaking.
I am very concerned about Ashley and Jason Stack, my neighbor's children.
You did the right thing, Mrs. Green. The children's safety is very important.
Mrs. Green had good reason to call the child abuse hotline. If anyone thinks a child is at risk, he or she must tell the authorities. Children and Youth Services follow up every call they receive. Follow-up does not mean that Children and Youth Services will always do a home visit or an assessment on the family. In this case, Children and Youth Services decided they had enough information to proceed with an assessment. Caseworker Brown called the Stacks' grandparents and found out the Stacks have been having financial issues. An assessment often involves a caseworker speaking to immediate family members, co-workers, and school authorities.
Hello, may I speak to Mrs. Stack, please?
Speaking.
Hi, this is Caseworker Brown with Children and Youth Services. A call has been reported about a fight between you and your husband on Saturday. Can you tell me what happened?
I'm sorry. My husband and I have been arguing lately, and he lost his job, and we've been struggling to pay the bills. It's never been violent. The other night, Ashley and Jason were...
We've got to get more money here. This is just crazy. It's gonna be fine. How many times do I have to tell you it's gonna be fine?
Jason's hockey and Ashley's baseball. I need you to get a job.
How many times do I have to tell you it's gonna be fine?
I feel like I've got 3 kids rather than 2. It was an accident. My kids were never in danger.
Children witnessing fighting, arguing, or family violence are considered to be victims of emotional injury. I would like to stop by for a visit this week. I can stop by around 4 on Thursday. Would that be convenient?
Yes, that'll be fine.
Who are you?
Hi, you must be Jason, and you must be Ashley. I'm Angela, and I'm here to visit your parents and see how you two are. Hello, Mr. Stack.
Who reported us?
I cannot tell you that information, but I will tell you that it is a crime not to report children who may be in danger. I am concerned about the fighting in your home.
Well, Kurt got a job and he starts work on Monday, and we know fighting in front of our kids isn't good for them.
Look, we had a family meeting and we explained the whole argument to the kids. And we apologized to each other and to our kids.
I would recommend family counseling and to have a list of resources, including family violence agencies and community agencies, that can assist you with things like basic needs, food, and financial counseling.
I mean, do we have to go to counseling?
You're under no obligation to go. It's just a recommendation. Before I leave, I need to speak with your kids privately. I must warn you that if there is another complaint, we may investigate further, and you and Mrs. Stack may be required to attend some of these programs prior to closing your file. I do wish you all the best. Please call me if you have any concerns.
The caseworker found the parents were willing to take the steps to prevent further fighting. Depending on your situation, it may or may not be in the best interest of your family to go to counseling and access the services recommended. You have the right to talk with legal counsel to make the appropriate decision.
All right. So that's a very short video that simply describes the Family Enhancement Act or the Family Enhancement process. People spend months training to learn how to work through this process. And so it is a simplified child and family services process, and we're going to walk through it from reporting to the various end results. So here is a simplified flow chart from reporting to end results. Please disregard the timelines that are in the flow charts, because about 30 seconds after I had this hand drawn and scanned into the process, it was, they had changed it. Go back. There. All right. So as we're going through, I will give you the correct timelines, but this is a simplified flow chart of how the process works. So the first thing that I want to mention is about reporting. First, you or someone else reports a child in need. It's actually against the law to not report a child in need. And in fact, what the Act specifically states is Any person who has reasonable and probable grounds to believe that a child is in need of intervention shall report the matter to a director. Any person who fails to comply is guilty of a criminal offense and is liable to a fine of not more than $2,000 or up to 6 months in prison in lieu of the fine. Notwithstanding, and in addition to any other penalties provided by this act, if a director has reasonable and probable grounds to believe that a person has not complied with this, and that person is registered under an act regulating a profession or occupation. So, for example, a registered social worker, nurses, teachers, doctors, psychologists, anybody that has to be a registered profession, the director, the department shall report the appropriate governing body of that profession or occupation, and there will be an investigation there as well, and potentially some disciplinary measures there as well, up to and including the ability or the loss of a career. So it's really important that if somebody suspects that a child is being neglected or abused in any way, that they are reporting it. So when I'm talking about reasons or grounds for why the department would get involved, there's a huge list of specifics in the Child, Youth, and Family Enhancement Act, but I've pulled kind of the biggies. Ultimately, any reason why the department would believe that the survival, security, or development of the child is endangered, they will get involved. And so some biggies: if the child is lost or abandoned, if the child is being neglected, or if the child's guardian is dead, deceased, and the child has no other guardian. A lot of people don't realize that if something were to happen to the parents and the parents did not leave a will expressing their wishes for who they would want to take care of the children should something happen to them, Children's Services legally has the right to step in and make those decisions for them. And so if parents or guardians do have underage minors in their care, it is really critical, really important that they have in writing the names of who they would like to take over being guardians, legal guardians for their underage children. If the child is at substantial risk of being physically injured or sexually abused, either by the guardian or by somebody else, and the guardian is either unable or unwilling to protect the child, the department will get involved. This also applies to emotional injury by the guardian or by somebody else. And when I say emotional injury, examples would include if a child is a witness to domestic violence. So they're not directly being physically injured. However, witnessing violence is very traumatic for children. Also, what they've discovered is children that are getting constantly criticized, demeaned, or if they are constantly being raged at, that also has a profound emotional effect on children. And so the department will usually get involved in cases like that as well. Also, if children are witness to addictions, whether they are directly affected or not, that is also classified as being emotionally injured. And so that falls under that category as well. So survival, security, or development of the child. Also, we have this sort of catch-all that if the child is being subjected to cruel and unusual treatment or punishment, again by either the guardian or by someone else, and the parent or guardian is either unable or unwilling to protect the child from that cruel and unusual treatment, then children's services will usually get involved. February 28th, 2019, there were some new guiding principles that were introduced. And so I've included them in the PowerPoint, and new guiding principles that CFS workers must always keep in mind. The best interest, safety, and well-being of children are paramount. That is the number one primary focus for them. However, that being said, that the well-being of families and communities is crucial to the well-being of children. Now, under the old Child Protection Act, child welfare workers, their primary focus and goal was solely the protection of the children, and didn't put a whole lot of effort into the well-being of the family. However, thank goodness, society has evolved, and so Children's Services now has to recognize that a healthy family and community is only going to be beneficial to the well-being of the children as well. And so while it is still their primary focus to make sure that the best interest, safety, and well-being of the children are paramount, at the same time, they also need to be working with the families to help them to recover, to restore health. Children benefit from lasting relationships with people with whom they have connections, including family, friends, caregivers, and other significant individuals. As well, the connections with their culture and culture communities and opportunities to form those connections, and permanent formalized ties with people who care about them. And so what this means is that if Children's Services is considering removing a child from their family, no matter how dysfunctional, no matter how unhealthy a child's family is, they love their families and don't want to be ripped away from it. And so Children's Services now also has to recognize that they can't just sever those connections to family, friends, and other people who have a significant relationship with them. As well, that they also have to take into consideration that child's culture and those cultural connections. Also, another guiding principle is that Indigenous people should be involved with respect to the planning and provision of services to and decisions respecting Indigenous families and their children. And so all throughout this process, Children's Services must try to inform Indigenous communities or Indigenous First Nations groups, Metis groups, to try and give them the opportunity to get involved in the service planning, and also to potentially make some recommendations in respect to placement and services for the children. And we'll get more into that. So there are also a huge list of considerations to support for child safety and well-being. Again, not going to go over, I will go over the first 5, but the rest are listed as well. that the child's family has the primary responsibility for the safety and well-being of the child, and the family's well-being should be supported and preserved. If the child is capable of forming an opinion, the child's opinion should be taken into account. In the case of an Indigenous child, the importance of respecting, supporting, and preserving the child's Indigenous identity, culture, heritage, spirituality, language, and traditions. The benefits to the child of lasting relationships with the people with whom the child is connected, including family, friends, caregivers, and other significant individuals. It's really important to know that one doesn't have to be related to a child in care in order to be involved. The benefits to the child of connections with the child's culture and cultural communities and opportunities to form those connections, and the child's race, spiritual beliefs, color, gender identity, gender expression, age, ancestry, place of origin, family status, sexual orientation, and any disability the child may have. So all of these things need to be taken into consideration as Children's Services is working with providing a safe place and a safety plan for the child and working with the family. So it's a lot to keep in mind. And you might be thinking, this is all common sense. Of course it is. But it's a major shift in the department's focus. And we've been making this transition for probably almost 20 years now, and we still have some work to do, but we're getting there. Some more considerations to make: the importance of stability, permanence, and continuity of care and relationships to the child's long-term safety and well-being. This one is also important, that any decision concerning the removal of the child from their family should take into account the risk to the safety, security, and development of the child if the child remains with the family, if they're removed from the family or if they're returned to the family. As well, that any extended family or others with significant relationships should also be considered for placement of that child, because it's very traumatic for a child to be taken, apprehended from their family. No matter what's been going on in that home, it's still going to be very traumatic to be forcibly removed. So what's going to cause the least amount of stress, additional stress, or trauma to that child? Being placed in foster care with strangers, or being placed with extended family or somebody else that has a significant relationship with that child. And so any decisions that the department makes regarding the placement of the child outside of their immediate family needs to seriously consider extended family or people with a significant relationship with that child. Again, there's lots. So we're going to start off with screening and intake. The department is legally obligated to consider every call, every report that comes into their office. And reporting can come in the form of a request for intervention services. What this means is that the department is actually supposed to be a support for families that are going through trauma or stress. And so if a family is going through a particularly stressful time and they do need or feel like they need extra supports, they are supposed to be able to contact Children's Services and request support services. So that's supposed to be in place, and hopefully we're getting there. A report under section 4 or 5. So that would be a report by a neighbor, medical professionals, teachers, anything like that. And of course, any other allegation or evidence that a child is in need of intervention. So, for example, in my early years with Native counseling, I was a court worker and I was assisting a youth, he was 12, going through youth court. And when I did my intake, what I discovered is that this youth had been charged with theft under $5,000. The circumstances were that he had stolen food from a bulk bin at a local grocery store, and he got caught. And he dropped the handful of open food back into the bin. And so the store had no choice but to get rid of the entire bin because it was contaminated. So I think the replacement cost was $1,200 or somewhere around there. When I talked to the youth, I discovered that his single mom and his older brother were both battling a hardcore addiction to meth. And so the majority of the household income was going towards supporting that habit. So the child was hungry and went into the grocery store and was trying to steal food. Under those circumstances, I didn't believe that the courts, and particularly strapping this youth with a criminal record, was the appropriate place to properly or appropriately deal with the situation. And so I explained the situation to the Crown prosecutor and the judge, who chose to withdraw the criminal offense and made a referral to Children's Services. And so then the child's situation was dealt with in a more appropriate manner. So sometimes situations will happen that don't seem really related, but red flags will go up. So unless the department is absolutely sure that the report was malicious, unfounded, or without reasonable or probable grounds, they have to do a risk assessment within 5 business days of receiving that report. And so they will do a quick risk assessment to determine if the child is in need of intervention. And then on or before the 5 days, we'll make a decision whether they're going to follow through and make a referral to either Child Protection Services or the Family Enhancement Department. However, I do want to also mention that every call, every report that comes into the department, Children's Services, whether they have found merit and opened a file, or if they've decided that there is no reason to open a file and they close that file, they legally have to keep all reports in their system for 99 years. The law specifies 99 years. So even if they have chosen to close the file with no action, there will be a report. And I just want you to be aware of that, because if, say, in the future, somebody decides to go back to school to become a social worker or a teacher or a youth worker, or they decide to take a job where they're working with vulnerable populations, they will have to get something called a child youth information check, SIM check. We used to call it quiz, child welfare information system. And that's where the department will run a person's name through their computer system. And these reports will come up. And so I don't ever want this to be a reason to stop someone. it means that someone will have to take an additional step. They'll have to sign a release of information so that the department can release the specific information regarding that report. So it might be that a report came in, they did a risk assessment and found that there was no merit, so they closed the file. All well and good. So just be aware that 99 years is a very long time. But again, if you have, if there is somebody that abused a child and then 20 years later applied to be a foster parent, you'd want that information to still be available. And so again, it's better to be safe than sorry. Now, I know that Indian is not the politically correct term, but I still use it because it falls under the definition through the Indian Act. And if you were to look in the table of contents or the glossary for information specifically regarding treaty children, you'd have to look under Indian child. So I still use it as a term of reference. Once the department determines that services are required for a recognized Indian child, so a child that is entitled to treaty status, the Act requires that the department has to. It's not a can do or should do, it's a have to. They have to notify a person designated by the Council of the Aboriginal Band in planning for the services to be provided to the child. In addition to serving notice to the band designate, if the child is a First Nation individual or a member of a band, the applicant, so the department, has to serve notice of the nature, date, time, and place of the hearing. So what's going to happen in court. So what is the department applying for? What type of order? When, date, time, and place, when and where is the court date, and they have to be served, the band has to be served not less than 30 days before the date of the hearing, so that the band or bands identified can decide whether they want to make representation or not. A band that is required to be served with notice of any children's services application have the right to attend court the first time the matter is heard in court, and then on that first appearance may make submissions to the court regarding the band's participation. So they can appear, they can be represented by a lawyer, they can make representations to the court. So recommendations on placement for the child, services for the child and the family, as well as future involvement in the case. If the court grants leave and subject to any conditions the court might impose, because the courts always have the final say, whether they take further part in the proceedings as well. So the band has two opportunities through this process where they have a fair amount of power, they have a fair amount of say. And so one is right at the beginning where they can get involved, they can request to stay involved in that court proceedings. They can also make recommendations on where the child should be placed and what services should be put in place for the child and the family. So the reason why these protective conditions have been put in place is so that we don't repeat history. So anybody that's ever heard about the 60s scoop, you know that Indigenous children were apprehended at a staggering rate with no regard to cultural connections, never mind family connections, and were granted permanent guardianship, and they were adopted out. not just outside of their culture and their families, but also in some cases, even outside of the country. And so there was this huge wave of loss of connection. And so this has been put in place to ensure that that doesn't happen again. Now, although the Act does not provide for Métis children, so there is no laws to protect Métis children and families, Children's Services have created policies that do include Métis children and will provide the opportunity to involve a Métis resource in case planning, support, and service provision. However, because it's policy and not law, it's a can do, but not have to. And so it's really important that if somebody is Métis, that they know that there's this policy available so that they can ask for it. So maybe they want their file closed in the mainstream system, and they want to transfer to the Métis Child and Family Services. Or maybe they would like the support services by the local friendship center, or maybe they want to get a Métis elder involved for support as well. So they do have those options available, but keep in mind they're policy and not law. So just be aware that you can ask for it, but it's not a have to situation. So we've completed the 5-day risk assessment, and we are now going to make a referral to the Family Enhancement Program. Now, the Family Enhancement Program is new to the Child, Youth, and Family Enhancement Act. Now, Child and Family Enhancement Act has been in place, like I said, for the better part of 15 plus years. So we do have this early intervention program that is available. If Children's Services does their 5-day risk assessment and they determine that the child's risk is minimal, after the 5-day intake screening, it will put supports in place for the family to address their issues. Like, so they don't have to apprehend the children. Children can stay with their parents, but Children's Services is going to put some supports in place to help the family to deal with whatever issues are causing stress or trauma to the child. And if there's no risk determined, then the file is closed, keeping in mind that even though the file is closed with no intervention, that report stays in their system for 99 years. So if somebody winds up being reported to Children's Services and Children's Services is talking agreement, that means that they're not planning on going to court. So the key words that people need to listen for is if the department is applying for an agreement or an order. If you hear the word order, that is your clue that you need to apply for legal aid or you need to get a lawyer involved because you are going to court. So a family enhancement agreement is private. It means that the department has determined that the child or youth is in need of intervention as defined by the Act. The child's need for intervention can be satisfied by Family Enhancement Services, and that the child's safety can be guaranteed or assured at least while still remaining in the care of their parent or guardian. This third point is critical. The department is always obligated to consider the least intrusive measures that can adequately protect the child. And so they can't just instantly apply for the most intrusive method to protect the child. They always have to consider what's going to cause the least amount of trauma to the child. And the parent or person who has custody of the child is willing to enter into the agreement. The primary goal of a family enhancement agreement is simply to eliminate whatever was causing the child to be at risk or in need of intervention. So I'm going to show our second video.
He'll be here soon.
I'll get the reception to call your dad.
Dad, you forgot to pick me up from school.
What time is it?
What's for dinner? Booze? He'll be here soon. You can go.
It's almost 6. I'm not leaving you here alone. Your father knows he's supposed to pick you up at 2?
Maybe he has a flat tire. Or maybe he'll be here soon.
I'll drive you.
Oh, what are you doing here? Andrew, what did you do? You're gonna get it, boy. Get inside.
Andrew didn't do anything. I drove him home because there was nobody there to pick him up after the game. Did you forget? Again?
Something came up. What's it to you?
Jack, I've coached Andrew for 5 years. And you used to come to every practice and game, and now I hardly ever see you. Are you okay? Since Kim died, I've noticed a change.
Why don't you mind your own business?
Children and Youth Services received calls from Andrew's coach and his teacher. Caseworker Brown did a detailed assessment. She gathered information about the family, and she met privately with Andrew at his school.
Hi, Jack.
Well?
Thank you for coming to my office.
Okay.
We've received a number of reports advising us that you are drinking a great deal and neglecting Andrew. I understand the difficulty dealing with your wife's loss. We need to address the situation.
Situation? What are you implying?
Jack, your drinking has interfered with your ability to care for Andrew. You've been intoxicated in front of him on more than one occasion, and you're expecting him to take on adult responsibilities.
Are you saying I'm an alcoholic? I'm not. I'm managing quite fine on my own.
It's clear from the 2 separate calls we've received about Andrew that you are not managing. We've become involved because your family needs our help.
It's just been so hard without Kim since her death. Sometimes I forget that
Andrew's just a kid.
Maybe it's time we let Andrew just be a kid. You need to start being his parent. For Andrew's best interest, we should try a family enhancement agreement.
What's a family enhancement agreement?
It's a signed agreement between Children and Youth Services and you, Jack. We are agreeing to create a case plan and cooperate together to complete the case plan.
Will Andrew be taken away from me?
No. Andrew will remain in your care and you will remain his legal guardian.
Well, what's this case plan?
I think your case plan should involve you attending a treatment program. There are many to choose from. We will start with an assessment, likely through ADAC. You will need to stop drinking completely. And I think you and Andrew would benefit from an in-home support worker. An in-home support worker will help you settle into a routine, update your parenting skills, and help address some of your grief issues.
This is a very critical moment in the process. If you do not agree with the Family Enhancement Agreement, you do not have to sign it. You have the right to talk to a lawyer, legal aid, or a court worker before you sign anything.
If you do not sign this agreement, Children and Youth Services will take this information to court because I feel Andrew is at risk in your care if you do not stop drinking. If this matter goes to court, you may lose your guardianship and custodial rights as a parent, either permanently or temporarily.
I don't know how my drinking got so out of hand. I know Kim would have wanted me to stop drinking.
Doing well? Yeah. Kids play really well together, don't they?
Hey, great job out there. Nice goal.
Thanks, Dad.
Yeah, I've noticed an improvement in your game in the past couple of months. Oh.
Yeah, my dad's been giving me pointers when we practice at the rink by my house.
Yeah, well, you take suggestions well.
Take care, Coach. Hey, how did you dig that guy out?
Jack followed through with the FEA. He worked with an in-home support worker who helped him with his parenting skills. Jack found community resources that helped Andrew and himself work on their grief issues. The FEA was reviewed between Jack and his caseworker. It was determined that there was no need for further intervention, and the FEA was not extended. If you think an FEA will work for your situation, ask questions. Make sure you can follow through with what you are agreeing to. You should consult with legal counsel to ensure you are making the best decision for you and your family.
Just to add just a couple extra comments about the Family Enhancement Agreement. Family Enhancement Agreements will generally not be for longer than 3 months, but can be extended with supervisor and manager notification. Again, the primary goal of a Family Enhancement Agreement is simply to eliminate the condition that caused the child to be in need of intervention, which involves putting services in place such as family support workers, accessing resources such as addictions, mental health, family counseling, as well as assessments for medical, psychological, etc. Entering into a Family Enhancement Agreement reflects the family's commitment to work together with the director, the department, to address issues relating to the child's need for intervention and provides the legal authority to provide family enhancement services. The CSF worker is to, during this time, ensure that the guardian or custodian has a full understanding of the purpose of the agreement, to ensure that the guardian or custodian has a full understanding of the services and supports provided through family enhancement services, to make every effort to engage the guardian or custodian in a collaborative and cooperative working relationship to address the need for intervention, to explore the family's abilities to access services available in the community, to explore the family's ability to contribute to the cost of services through financial and in-kind contributions, and to negotiate the agreement in a way which addresses the need for intervention and provides the basis for further planning and cooperation. Agreements can be varied, extended, or terminated at any point in the order as the need arises. If the parent or guardian requests a termination of the agreement, the CFS worker has 3 days to determine the next course of action, either to close the file or make a further application in court. They're also going to create something called an aftercare plan. An aftercare plan will be developed at closure to assist the family or youth to maintain the changes that were experienced and to provide the family or youth with tools and strategies to address the kinds of issues that may indicate a need for further supports, which would include specific strategies that the family or youth can use to deal with issues in a planned and positive manner, strategies to maintain the changes they have experienced, a list of resources, including telephone numbers and names of community and network supports who they can contact should they need to. Ideas on how the family or youth can self-identify issues that may require attention before a report goes into Children's Services, and strategies and an understanding of the supports in the community that they can turn to themselves. So now we're going to go back to the screening and intake, but this time we're going to, for the sake of the workshop, say that Children's Services has determined that the risk to the child is great. And so they're going to make a referral to the Child Protection Investigation Officer. And at this point, the Child Protection Unit has 10 days, 10 business days to do a complete investigation where they require, if they require more information to make a decision. If they require more than 10 days, they have to, at this point, get a supervisor or manager involved. It's not like the old days when they could sit on a file for long lengths of time. I want you to keep in mind 45 days, 45 business days, because that is ideally how long Children's Services has from the time they receive a report to the time they have a case plan in place and everything is a done deal. Court applications, case plan, 45 business days. Now that's ideal. That's what they're supposed to be aiming for. Now, I certainly understand the idealism behind the Child, Youth, and Family Enhancement Act. It's to ultimately try and get children to be in a permanent placement as soon as possible. Maybe you know somebody, an adult, who spent the bulk of their childhood in care, and they were literally bounced from pillar to post. They might have been apprehended and placed in foster care, only to be returned to their family and then reapprehended, but this time they were placed in a group home. And so they spent the bulk of their childhood being bounced all over the place, and they didn't form a solid foundation. And so when a child grows up without a solid foundation like that, they wind up with identity issues, poor coping mechanisms. Maybe they've turned to addiction. There's often domestic violence, homelessness, unemployment. And so huge, huge issues caused by the further trauma that children's services intervention creates. And so the idealism behind the Child, Youth, and Family Enhancement Act is that children will be placed permanently as quickly as possible. The ideal would be placed permanently back with their immediate families. But if they can't, then the department has to take a serious look at extended family and people that have a significant relationship with the child, because again, the ultimate goal is always permanent placement. So depending on what the issues are with the family, the department may need to look at permanent placement outside of the immediate family very quickly. So again, I understand the idealism, but it's a real balancing act, and I don't envy the job that they have. So that being said, I'm going to show the last part of our video.
Haley. Haley.
Sorry, Miss Clark.
Did you not get enough sleep last night?
I tried, but my mom and her boyfriend was up late last night. Couldn't sleep.
You can go home. Please don't be late for homeroom tomorrow. And do your homework. Wait a minute. What happened to your arm?
I fell.
Where did you fall?
I don't know. Can I go home?
So, can we schedule with the parents next week?
Principal McKee, I'm concerned about Haley Breen. I think we need to make another complaint to Children and Youth Services.
Again?
Caseworker Brown was very familiar with Haley Breen. Haley had a long history with Children and Youth Services.
Hello, Justice Martin. I know it is after hours, but I need an apprehension order for Haley Breen. We've received another complaint from her teacher, and I will need a clause for a police escort.
Caseworker Brown felt Haley was in danger and needed to be apprehended.
What did my boyfriend do now? Jimmy! Jimmy!
Miss Breen, you're being served with an apprehension order.
A what?
We have to take Haley.
Can't take my baby. Don't take my baby. Please.
Miss Breen, let her go.
No, don't play with me. I need my baby.
Haley immediately went into foster care. Caseworker Brown filed a permanent guardianship order for Haley. A PGO was filed because of Haley's previous time in the care of Children and Youth Services. A child can only have a certain number of days in care before other permanent options need to be made. Caseworker Brown passed Haley's files onto the court coordinators for Children and Youth Services. The court coordinators represent Children and Youth Services in court. The initial custody hearing happens after the apprehension. The court coordinators need to show the court why the apprehension was appropriate. In this situation, the judge agreed and apprehension was the right thing to do. Children and Youth Services was granted initial custody of Haley and a trial date was set for the PGO.
I have spoken with Ms. Breen and she is not the abuser. She's moved out and is no longer in contact with him. She understands the PGO and will agree to the PGO as long as she can visit Haley.
Due to the circumstances, they would have to be supervised visits.
That's fine with me.
And Ms. Breen is willing to attend treatment.
That will be noted in your file.
Ms. Breen, do you understand what you are signing and what this means to you and Haley?
Yes.
Miss Breen, her NCSA court worker, and the caseworker attended the court date. The PGO was reviewed by her NCSA court worker to make sure it included what was discussed in the meeting. The court coordinators presented the PGO and report to the judge. The judge read the report and granted the PGO, which allowed Haley to visit her mum.
She's late.
Hi, my girl. I am so sorry the bus was running late.
Miss Breen attended treatment. She is prepared to work with her caseworker and so far she has attended all of her supervised visits with her daughter.
I miss you.
I miss you too.
It's a long road, but you can work with your caseworker to get your child back after a PGO has been granted. It is in your best interest to work with your caseworker. If at any time you are involved with Children and Youth Services, you should get a lawyer to help you understand the legal rights and responsibilities of your family. An NCSA court worker can put you in touch with legal aid. Thanks for watching.
So as I'd mentioned earlier, if the screening and intake determines a child is at risk, Children's Services has 10 days to complete a child protection investigation. If after the 10 days they require more information to make a decision, they can take 10 more days to complete an extended investigation, but they do have to get, at this point, their supervisor or manager involved because time is very critical through this process. If a child is in need of intervention, Children's Services may obtain permission from a judge or a justice of the peace to pick up the child from any place that the child may be found. Peace officers may assist them. The Act states that if a director has reasonable and probable grounds to believe that a child is in need of intervention, the director may make an ex parte application, so that means without served notice, application to a judge of the court or sitting presiding justice of the peace for an order authorizing the director, the department, to apprehend the child from any place where the child may be found. And if they are anticipating that they are going to require force, that they can also call for the assistance of a peace officer. A child will be apprehended if they cannot be adequately protected while a supervision or guardianship order is being applied for. The CFS policy states a child is to be apprehended only if the child cannot be adequately protected pending a direct application for a supervision or guardianship order. Once the child has been apprehended, Children's Services must provide notice to the guardian, either spoken or in writing, that the child has been apprehended, their intent on where they're going to place the child, and what order they're planning on applying for. Notice may be given either written or spoken and shall include a statement of the reasons why they apprehended and the telephone number of the nearest office for the Legal Aid Society of Alberta. The proceedings under this act is not affected if the director is unable, after a reasonable effort, to give notice. So if they're not able to find the guardian to give them this notice, it's not going to stop the process. In fact, it's probably part of the reason why Children's Services needed to get involved. The Act also gives child and family service workers direction when a child has fled from care and a home is believed to be concealing them. So they do have the ability to perform searches there as well. Children's Services or a peace officer may apprehend a child without an order if there are reasonable and probable grounds that the child's life or health is seriously endangered because the child is either abandoned, lost, or has no guardians. If the child has left the custody of their guardian without consent, or there's substantial risk that child will be physically injured or sexually abused. Yeah. However, just because the department has the ability to do an emergency apprehension without actually getting an apprehension order, the paperwork always has to catch up at some point. And so if the child was apprehended under Section 19, so the emergency apprehension, Children's Services has 2 business days to make an application for some type of order, a supervision order, kinship care, a temporary or permanent guardianship order, or if they want to return a child to a guardian outside of Alberta, they would still need to make an application to the courts to be able to transport that child to another province. So when we're getting into the different programs under the child protection stream, the first and least intrusive order is the supervision order. Now, this is typically what the department would apply for if they had made a recommendation for a family enhancement agreement and the family was not willing to enter into that agreement. And so if they chose not to work with the department under a family enhancement agreement, the department has generally 2 choices. They can either close the file, which almost never happens, or they can apply for some type of court order. And typically what they would apply for is a supervision order. So this is like exactly like a family enhancement agreement, except that the significant difference is that now a judge is ordering the family to work with the department. So it's mandatory supervision of the child and their caregivers. But the positive is that the child still remains in the care of their guardian or parent. Supervision requirements will vary with each order because everybody's situation is different. And so the supervision requirements or case plan is going to vary to address individual situations or conditions. So then the next program under the protection stream is new to the Child, Youth, and Family Enhancement Act, and this is the kinship care. Prior to the Child, Youth, and Family Enhancement Act, the only ability that extended family had to get involved or to assist, to offer supports to a family with children at risk was if they applied for private guardianship. And the private guardianship application had to be approved, consented by the department. And then under a private guardianship order, that extended family might have received financial support in the neighborhood of, $80 or $90 a month. Well, I can tell you that my dog's food and treats come to more than $80 or $90 a month. Being able to offer supports to extended family should not cause a hardship on that extended family. And so they've created this option called kinship care. And how I think of kinship care is like foster care light. So a kinship care home is a family that is approved to care for a specific child because they're related to the child or they have a significant relationship with that child. The law says that the benefits of placing a child with extended family and those people who have a significant relationship with the child must always be carefully considered. Approval, so Child and Family Services policies clearly state that careful consideration should therefore be given to finding a placement within the child's extended family or significant relationship network when a child is brought into care. Because remember that third point that I had talked about, that the department is legally obligated to consider the course of action that is going to cause the least amount of additional trauma to a child. And so if a child has to be apprehended, taken out of their immediate family's home, what's going to cause the least amount of additional trauma? Being placed with people that they know and care about, or being placed with strangers in foster care. And so it's really critical that the department works very hard at trying to find an alternative home that the child already has a relationship with. So approval of a kinship care home involves a completion of an application to become a kinship care provider. The department needs to complete a home assessment for adoption, foster care, and private guardianship and kinship care. After all, it is foster care light. The department needs to make sure the family is provided with caregiver orientation training. They need to complete an intervention record check. Remember that quiz or sim check to make sure that 20 or 30 years prior that they weren't, didn't have a history of child abuse or some type of other relevant related incidents. And not just a quiz check or a sim check for the applicants, but also on any other adults living in the home. They need to advise the applicants that each adult in the home must provide the results of a criminal record check before the home can be approved. A criminal record does not necessarily prevent approval, as the nature and circumstances of the offense will be considered. And so if another adult in the home has a criminal record, but let's say it is old and it has nothing to do with violence or child abuse or neglect in any way, that in itself should not be the only reason why that family would not be considered as a kinship care provider. They need to obtain a completed criminal records check for all adults living in the home. The cost will be reimbursed by Children's Services. A completed home assessment report, a completed safety environment assessment. They must provide current medical references, and they must provide the names of 3 references from the applicants, one being a non-relative. Now, this might seem like a very long, lengthy process, and it is, but Children's Services will do or can do a very quick home assessment, place the child or children with them, and monitor the situation while the family completes this kinship care application. Once the family is approved as a kinship care home provider, then they will also qualify for financial support equal to the foster care base rate. So depending on the age of the child, could be anywhere from $600 to $900 per month, which is more in range, more in line with the cost of raising a child, the increase in your groceries, your electricity, your power bills, providing clothing and school supplies and all of that. Again, I can't stress enough that it's wonderful that extended family would be willing to help support their extended family by opening their doors to their child or children, but it shouldn't take away from their children. So it shouldn't cause a financial hardship. The law clearly states that the benefits of placing a child with extended family and those people who have a significant relationship with the child must be carefully considered in each case. So then we get into something called a custody agreement. And remember, agreement means private, order means you're going to court. So a custody agreement is a private agreement between the department and a family, but it's a bit of a double-edged sword. The maximum length of time for a custody agreement is 6 months. The parents during this time retain guardianship, so they're still classified, still considered legal guardians, but they agree to give certain responsibilities to Children's Services. An agreement would include a plan for the care of the child, services that are to be provided during that time, and what type of guardian or parental visitation or access, and who is going to facilitate that. Section 9 of the Act states that a director may enter into a custody agreement for a term of not more than 6 months if, in the opinion of the department, the child is in need of intervention, the survival, security, or development of the child cannot be adequately protected if the child remains with their guardian. The policy manual directs that during the term of the agreement, the parent maintains their legal guardianship authority, but shares some responsibilities. A concurrent plan must be completed within the first 42 days of the child coming into care of the director upon the completion of the initial assessment. I always say, always consult a lawyer before entering into a custody agreement. Considerations that need to be made before entering into a custody agreement. If the child is in fact at risk, are there any less intrusive measures that could adequately protect the child without being taken into care? The parent must agree that the child needs to be taken into care. The parent is willing and able to participate in the planning, and the parent will maintain involvement and does not wish to be, does not want to eliminate their parental responsibilities. Now, here's the risk with the custody agreement. If after 6 months being in care under a custody agreement, if the parent or guardian is unable to resume custody of their child, then the department has no choice. They have to make an application for some type of order. And here's the dicey part. The department, once they make that application for an order, the clock starts at 6 months because they have to include the 6 months that the child was in care under the custody agreement. Now, that might not seem like a big deal, but there are definitely short time limits that children can remain in temporary and permanent custody care. And so the maximum amount of time that children can remain in the department's care, whether it's under a custody agreement or that plus a temporary or permanent guardianship order, is 15 months for a child under 6 years, or 18 months for a child over 6 years. And that includes any extensions, because ultimately it's a maximum of 9 months for children under 6, with a potential for a 6-month extension if the family merits it. So they've been working diligently, and it looks like there's a really good chance that they could resolve their issues. They could be granted a 6-month extension. And for children over 6 years, that's actually only 12 months with a potential 6-month extension. But with the extension, the absolute most time that children can remain in temporary care is 15 to 18 months, depending on the age of the child. All right. So let's talk a little bit about temporary and permanent guardianship orders, which is the most serious. Any family that's going through children's services, you hear temporary or permanent guardianship order, you really do need a lawyer at this point. So with temporary guardianship, the child is determined or assessed to be in need of intervention. The survival, security, or development of the child cannot be adequately protected if they remain with their guardian. There's those 3 words again. And it's expected that within a reasonable amount of time, the child may be returned to the custody of their guardian or parent, or if the child is 16 or older, would be able to live independently. So what this means is that when the department, right from the onset, right at the very beginning, when the department is doing their assessment and their investigation, and they are assessing how long it will take the family to resolve their issues, that will determine whether they're applying for a temporary or a permanent guardianship order. If it looks like in their assessments and investigation that the family will be able to resolve their issues within 9 to 12 months for children under 6, or 12 to 18 months for children over 6, then they may apply for a temporary guardianship order. The temporary guardianship order must include, so the order itself must include the number and conditions of visitation or access to the child, or by any other person who has a significant relationship with that child. Another new thing to Child, Youth, and Family Enhancement Act, children over the age of 12 must sign a consent form allowing access or visitation from people that they, like family or anybody for that matter, that has a significant relationship with that child. If the child who's 12 or older refuses to sign that consent form, visitation doesn't happen. Now, it doesn't mean that the department's just going to wash their hands of it and say, oh, well, c'est la vie, done. It means the department needs to find out what's the problem, and we'll need to put some services in place or some supports in place to heal that relationship significantly enough that the child at some point will sign consent for access or visitation. The order is also going to include when Children's Services must consult with the guardian or parent on matters that are affecting the child, because under a temporary guardianship order, parents still are considered legal guardians and must be notified of any decisions being made regarding their child. If recommended by Children's Services, participation by the child or the guardian or both in any treatment or remedial programs. And of course, we know that anything that goes before the courts, the judge likes to have the final word. And so any other terms that the judge considers necessary will also be added to that order. And I had talked about time is critical through this process. That again, in an ideal world, that the department is always in the back of their mind, keeping our thinking permanent placement, because the last thing they want is for children to be bounced all over the place for the duration or the bulk of their childhood. And so if they feel fairly confident that the family can resolve their issues within that 9 to 12 or 15 to 18 months, depending on the age of the child, they will make an application for temporary guardianship. However, before I get into the permanent guardianship, no matter what they apply for, whether it's temporary or permanent guardianship, the department has to be developing something called a concurrent plan. So the concurrent means something that's happening at the same time as something else. I prefer to think of it as plan A and plan B because it's easier to sort of wrap my brain around it. So while Children's Services applies for temporary or permanent guardianship, the guardian and other family members will help to develop, well, hopefully, will help to develop a plan A and a plan B. One of the provisions in the Child, Youth, and Family Enhancement Act is a family group conference. And when the Child, Youth, and Family Enhancement Act was first enacted, family group conferences had to legally be considered for every family that went through the system. However, that was fairly quickly repealed, gotten rid of, because it was time consuming and costly. However, just because it's not legal law, the department has kept that in their policies. But remember, policies mean can do, but not have to. And so it's important that people understand that there is a policy that does give families the right to request a family group conference. And this is where the family will work with a family group conference facilitator in developing their own case plan as well as the plan B. So plan A is your case plan. This is what the family needs to do in order for the child or children to be returned to them. And that can include counseling or addiction counseling, treatment, whatever. It's going to be specific to that family's situation. So plan A is the case plan. Plan B determines what permanent placement is going to be there for the child if the family is unsuccessful in completing their case plan. And nobody wants to plan for failure. But the reality is, plan B a permanent placement plan is going to be created. The only choice that families have is who's going to create that plan? A caseworker who does not know your family or the family. And so it's like not having a will. If something were to happen, who would you like to decide where your children are going to be placed? Do you want that control, that do you want to be able to make that choice, or do you want a stranger to make that choice for you? And so regardless, plan A and plan B are going to be made. Your choice is who's going to make those plans. Now, with the Child, Youth, and Family Enhancement Act, because timelines are so short, if right from minute one, if the department's investigation and assessment indicates that the family is not going to quickly be able to resolve their issues, legally, the department has to apply for permanent guardianship orders right from day one. And in fact, sometimes the department will make a kinder choice by applying for a temporary guardianship order, only to have the judge look at the situation and say, why are you not applying for permanent guardianship order here? And will adjourn the matter and order the department to make an application for permanent guardianship. However, permanent is such a scary word, and they shouldn't call it permanent, because permanent doesn't necessarily mean permanent where the permanent guardianship order is concerned. So once the department decides they're going to apply for permanent guardianship, it means that the department, the director of children's services, becomes the sole guardian of the child, and any of the child's assets are then held in trust by the public trustee. The director and the child, if they're 12 years or older, can allow for the former guardian or parent or others with a significant relationship with the child to have some kind of access to the child. Again, children over 12 have to sign written consent to allow for any visitation from anybody that has a significant relationship with them. And once the department is granted permanent guardianship, the parents or former guardians no longer have any authority over the child's care. What this means is that the parents no longer are considered legal guardians to their children. Again, that sounds very scary, and it is very scary. Conditions for a permanent guardianship order: the child is at risk or is already under a temporary guardianship order, and that time deadline has hit. The survival, security, or development of the child cannot adequately be protected if the child remains with or is returned to the guardians or parents. And it's not expected that the child could or should be returned to the custody of their guardian or parents within a reasonable amount of time. But remember, I said that permanent no longer means necessarily permanent. It could, but it doesn't necessarily have to. A permanent guardianship order will remain in effect until the order is terminated by the courts. What this means is that after a child has been in care for 2 years, the family can apply to the courts to terminate a permanent guardianship order. So we always recommend that even if children are granted permanent guardianship status, that the family continues to work with the department and that they continue working on their issues. At this point, they are fighting a bit of an uphill battle, but it's not impossible. It's not impossible. So continue maintaining a relationship with your child and continue working on your issues because you can always apply to terminate that order. If a private guardianship order is made in respect to the child, so if an extended family member or someone with a significant relationship to the child applies for private guardianship and it's consented, the judge has okayed it, then once that private guardianship order has been made, then Children's Services closes their file because it then becomes a private family matter. If the child is actually adopted, then Children's Services involvement ends. Or if the child turns 18 or marries, whichever occurs first, then Children's Services closes their file as well. Remember, I'd said right at the beginning that there are two places in this service array where First Nation bands have an incredible amount of power. One is right at the beginning where they can represent in court, they can make recommendations on placement and services, but also on the back end. If a child is treaty or entitled to treaty status, the only way that the department can legally place that child up for adoption is if the band consents. If the band doesn't consent, then that child will never be able to be legally adopted. And so the band has an incredible amount of power at that back end as well. And so there we've made it from start to finish. Now, I would really encourage that, if anybody ever does need to deal with the department, don't deal with them alone. These caseworkers have a ton of work to do in a very short period of time, which means that if they can push people through this process quickly, they will. And they have a very tough job to do. I wouldn't want to do their job, that's for sure. And so people need to be supported through this process. Okay, so never deal with the department alone. The other thing I would like to say is, please check out our resources, www.bearpawlegalresources.ca. We have several videos. We have a video on kinship and foster care, a video on applying to terminate permanent guardianship orders, and again, lots of publications. We have a wallet card for what people's immediate rights are when their children are being apprehended. So check it out. So lots of information. And it is, I don't mean to make it sound like this process is just so simple. It's not. Anytime people are dealing with their families and having their families ripped apart, it's emotionally so painful, so very traumatic for everybody involved. And so it's not a simple or a quick process, but there are some definite short deadlines to keep in mind. And remember, don't deal with the department alone. Call a court worker or apply for legal aid and get a lawyer on board as well. So that being said, I would like to say thank you for attending this webinar on the Child, Youth and Family Enhancement Act. I hope you got lots of useful information out of it, and check out our website. So take care, everyone. Zoom wave, and have a warm week.